Hey, well, good day, everybody. Let's take a look at the exclusive right to sell, exclusive listing contract, exclusive right to there's lots of names for this thing, but in the end, they're all the same. So this one, what you'll have, starting with all the dates, again, most of this information will pre-fill. I am using a generic one, which simply means that the office name is not on it, but it's got a contract date and a listing date. And that's so that it really kind of fits all of the locations for our offices. So the contract date is the date that you sign it. The listing date is when the listing is going to be submitted and marketing begins on the property within the multiple listing service. Through the expiration on whatever date that may be, this will automatically be on your purchase agreement. That will be the office name in that situation, address of the firm, the office, your designated agent, your email, all of the information. Again, supervisory broker, that needs to be a question to your broker manager when you sit down with them. Not all are associate brokers, therefore they may just be managing and could not be a supervisory broker, which case they'll tell you who to put into that blank as a supervisory broker. Obviously, the seller's names, their home address, the email addresses, the seller's phones, and then we get into the meat of the contract, which is, here's an agreement. It is between the brokerage firm and the sellers, giving the broker the right to market the property. We're going to use our full due diligence, and it does address the aspect that we are designated, that the designated agency or the designated agent and the designated supervisory brokers are the only ones to represent this seller. From there, we've got the property, checking as a village, township, or city of, fill in the appropriate information. Again, often this will just automatically pre-fill should you do this right using all of the, such as Remine or Transaction Desk. The year built, we're basically having them do a bit of a disclosure regarding the lead-based paint in advance. We're just having them check the appropriate box, okay? Everybody's good with that one. Price and terms, what price are they giving us to actually have as a target to be able to market the property at? What is that price? What are the terms, conditions that might be in accordance with that for that blank line? But really, it's just under what financial terms are we offering this? Typically, it's cash to new mortgage. There are others that are possibilities. Your broker manager will relay those out to you should you have anything else. I would simply tell you if you have a land contract, you should be getting your broker manager involved anyway. Now, the other part is it's saying that they're authorizing us to sell the property for a certain dollar in certain terms, or, and this is key when it comes to the time of getting the purchase agreement, or at such other price and on such other terms and conditions as the seller may agree to in writing. So this is that part, because normally what we know is an agreement does get negotiated with terms different from the way that it was listed. Inclusions. So we're now, again, guys, what we know, we sell land. We're really selling real estate. Real estate is the dirt, the lot, the meets and bounds legal description, and then anything that's permanently affixed to that. So all of the buildings, all the fixtures to that building, anything permanently affixed, it's also saying that they're agreeing to transfer all gas, oil, and mineral rights. Anything else that would be permanently affixed to the property, any support that may not be affixed to the property. It also now will have in here the TV mounts and brackets. Then along with that, anything else that the seller is going to be leaving that would be personal property. We're going to put that in advance. And one final line is if the seller has anything that is to be excluded from the property, we're going to put that on this last line. And of course, what do we always tell them? So if somebody says, I'm going to take that chandelier, that was my great-great-grandfather's. take it down before we have any showings. Yes, but it might help sell it, and that's the problem, right? So if that's going to be the situation, we don't want it there, because then it's going to get in the way and you may lose your chandelier that has apparently the emotional tie to it. The important part, compensation. If during the term of this listing anyone who produces a buyer ready, willing, and able to purchase the property as listed price and terms or any other price, terms, or exchange which the seller consents in writing, seller agrees to pay brokerage fee, a fee equal to $395 and a commission equal to blank dollars or blank percent of the sale price. So the first part of it is simply the amount that we're agreeing to accept in regards to compensation. So it's a $395, our compensation is $395 plus 3%, or excuse me, get on the right agreement here, plus 6% of the sale price. On this one, we're 6% because we're collecting, and we'll further clarify as we get into the aspect of cooperation. So just know that rarely will you use this. If you're going to use this, you know that you're using it. We're always going to be 6%, the $395, and then when you get into the protection clause. So the protection clause, you'll remember, is that time period from when the listing may expire to where they cannot accept any offer, sell it to anyone whom we've marketed the property to within 180 days, or in this case, we've transferred it to 6 months. So that is a protection period that you learned in your pre-license training class. All right? From there, it moves into the aspect of participation within the multiple listing service. And it's the seller authorizing us to participate, put the listing in there, and cooperate with all of the other brokers and agents within the MLS, which then takes us to the last part, really dealing with compensation, and that's how the cooperation will work. How will we compensate other agents who may bring us a buyer? Now, if you've been in the business or been with us, I might be throwing something out here that you're not going to necessarily like or agree. You could feel free to give me a call and I'll explain why we're going to do. What we're now having is to indicate and have the seller agree as to whom we're offering compensation to and what amount. We're going to make sure that the seller understands we are not going to offer compensation to a sub-agent. We will offer compensation to a buyer's agent and a transaction coordinator, and we will offer a fair market compensation. In our case, we get 6, we're given 3. You can work with your broker manager in regards to any exceptions that might exist with that. But we know we take a full 6% with the seller, we take a full 3% with the buyer, and within this then, we will offer 3% and 3%, and this is the part that some of you will go, well, wait a minute, why would we ever compensate? Guys, get a full understanding what a transaction coordinator is. That's the best I can answer for you without an actual course on that by itself. So in the end, the sellers will initial that we're compensating a buyer's agent. They will initial that we're compensating a transaction coordinator. We will leave this because we don't want someone else representing our seller whom we don't have any control over, understanding or training or knowledge or anything of that nature. We will have 3%. We have 3%. All right, let's move on. Title. Seller's going to go ahead and get marketable title, transfer the property, free and clear of any liens. Therefore, they're going to provide an owner's policy of title insurance to the purchaser. Special assessments. They're agreeing to pay any special assessments that may be due and payable, confirmed by the public authority, and then, unless otherwise negotiated as part of the buy-sell agreement that comes on. But again, this is what they're agreeing to in advance is the way that you want to see this one. Required certifications and inspections. If certification or inspection of the property is required by local ordinance, state, or federal law, seller agrees to pay for said certificate inspection. Seller further agrees to have any and all repairs required by such certification inspection made, provided they do not exceed blank dollars. So again, the thing to remember here, this is the agreement between us as the brokerage and the seller, that they're agreed to take care of certain things with the way that we've got price and terms. Nominal amount, it's not going to be real key, I guess is the way I would put it, but it could be you take a look at a property and you're thinking, man, there's a lot here, then it's $1,000. If you see next to nothing, it could be $100. All right? County well and septic compliance. Just that they're agreeing that if they're in one of those areas where it is necessary to do well and septic, they're agreeing to be able to take care of that. Default, they're getting into the point if a sale is not consummated, what works, how does it work? So let's just read this one on default. If a sale is not consummated because of a seller's refusal to perform, then the total agreed upon compensation shall be due and payable upon such refusal. If a sale is not consummated because of the buyer's failure to perform and the deposit made is forfeited, seller agrees that said deposit shall be applied first to reimburse brokerage firm for all expenses, and that 50% of the remainder of such deposit, but not in excess of the amount of total compensation, may be retained by the brokerage firm in full payment of services rendered. So if the deal falls apart for any other reason than what the purchase agreement will allow, and the seller is successful in procuring a portion or retaining a portion of the earnest money deposit, this says that we may retain 50% of that, but not more than what our compensation actually was. Guys, when it comes to that, I can tell you that I can't think of a time where we actually have retained that, and the reason being is because we still have the seller we're still going to sell. All right? Always work with your broker manager whenever you have a situation like that. Showings and signs. It's saying that, hey, you actually will get the opportunity to be able to do this. We will put the for sale signs out, even to the point where we get to the lockbox, that they're authorizing a lockbox to be able to be placed upon the property so that the property is accessible. Page 3, referral. Anybody that they know that inquires about the property, they are going to tell us about those individuals. This is a key one that I want you to know. Once seller and a buyer enter into a binding sales contract, the brokerage firm shall not present to the seller any additional offers unless seller and brokerage firm agree to otherwise in writing. So, in advance, here's what you need to know, and this will coordinate with our purchase agreement. This is contradictory to what state law says. But because this is in writing, it's the way that we're able to go. Brokerage firm shall not present to the seller any offers unless it's agreed upon otherwise afterward. But you need to know that this is what the listing contract says. We're then agreeing to the aspect of possession. Possession is to be given blank days after close of the sale, subject to the rights of present tenants, if any. An occupancy charge, if any, will be agreed upon by the seller and the buyer. So really all we're doing is what's the time period they're saying that they need? That could be TBD, 30 days, 60 days, probably not more than that. Number 18, guys, is a key one. It deals with citizenship. Seller is a United States citizen, yes or no? It's a simple question, but don't glaze over it and don't assume. This deals with FIRPTA. And now is the time to find out whether or not you've got a non-citizen, if you will, a legal resident, non-citizenship, FIRPTA. Don't glaze over it. Heirs, common one, and within this agreement shall be binding on their heirs, personal representatives, administrators, executors, signs, and successors. Non-discrimination, here's what we all know. When it comes to discrimination, we don't do it. Doesn't matter. Just flat out does not matter. So we just need to ignore that, becomes the bottom line. All money is green, all individuals are the same. We will not discriminate. Showing property. Now this is where we get a conflict of interest. So it says that the seller agrees and understands that as part of the marketing of the property, that the designated agent will show potential buyers properties other than the seller's property. So it's saying that, look, you're not exclusive to us to that point. We'll still show it to lots of buyers and other properties also. And provide such buyers with information on the selling prices in the area. Seller also understands and agrees that designated agent can show sellers property to and obtain offers from all prospective buyers, including buyers with whom brokerage firm has an agency relationship. So what I want you to know is we are getting agreement in advance that dual agency is actually okay. So here's what it says. We're now right at this point. If a potential buyer is represented by a designated agent within the brokerage firm, and note, guys, a designated agent within the brokerage firm, other than a designated agent. So we are not dual agency yet, but we're talking about the brokerage firm and the supervisory broker shall automatically be deemed disclosed consensual dual agents. Through all of our documents, the listing contract, exclusive right to sell, exclusive listing contract, buyer representation agreement, whatever you call them, buyers and sellers are agreeing in advance that we will be practicing dual agency. The first part of this is dealing with the supervisory broker becoming a disclosed dual agent, disclosed consensual dual agent. But then we break into the part where it's you representing both buyer and seller, representing both buyer and seller. If a particular buyer is represented by a designated agent, the designated agent shall notify both seller and buyer, and designated agent shall act as a consensual disclosed dual agent of both the seller and the buyer. So guys, what it's saying is you must redisclose. You must redisclose. In all cases, brokerage firm shall be entitled to total compensation provided in. Designated agent will preserve any confidential information obtained during another agency relationship or in a prior or pending transaction or business relationship. Seller acknowledges and agrees that the preservation of this confidential information shall not constitute a breach of any fiduciary duty owed by the designated agent to the seller. I think that part's pretty much self-explanatory, so I'm going to continue on. Indemnification. Sellers shall indemnify and hold harmless the brokerage firm and brokerage firm's agents and cooperating brokers and agents from any and all liability for any reason or result of injury to person or damage or loss of the property arising out of the showing of the seller's home pursuant to this listing. Now there's another thing that I love about what we've got now, and that is the unoccupied vacant properties. Broker assumes no responsibility for monitoring or maintaining the property or any damage that might result from weather conditions, including a freeze. Leave us alone, it's not our fault. Broker recommends the property be professionally winterized by a licensed plumber and that the heat and electricity remain on. It's just a great policy for all of us to make sure that the seller is aware of regarding these items. Representations. Seller acknowledges that brokerage firm is relying upon the representations, whether oral or written, made by the seller with respect to the property. Seller warrants to the brokerage firm that any representation seller has made or shall hereinafter make our true and designated agent is authorized to make such representations to the prospective buyers. Just say, hey, tell the truth. You're authorizing us to be able to share and work with these things. Unplatted lands, guys, this could be a course all on its own. But the short story to it is, there may be on larger parcels divisions left that could make property more valuable because they could split those larger parcels into smaller ones, collecting more money. So what I want you to know right now is that what you may do, if a seller's really ready to get the most money possible, here's what we want them to do. Give all the remaining divisions. All. But they need to know, if they don't know if there's any at all is going to be the answer. If they're looking to retain some, then they probably know how many are left. Just know that, get with your broker or manager and be able to find out how to be able to take care of these things. And at that point, last part of it is just checking off if the parcel is a new division, that it's been approved or that it still needs. And you'll know when you run into those. Seller's disclosure is simply that they will complete a seller's disclosure statement. Typically, we know that we always precede this with an agency disclosure. We know that we're designated agency, and we know that following this, there's other paperwork, but most importantly, or at least one of the most important ones, is the seller disclosure. Limitations, again, this is going to coordinate with the buyer representation agreement, the purchase agreement, and it's limiting them to 6 months or whatever the state limitations are that are governed through our laws. Electronic communication, in simplest part, it says that, look, we can deliver contracts and so on via the electronic, digital, in most cases, it might be Reminder transaction desk. There's lots of ways to be able to sign digitally and transfer all information agreements. That's just simply saying that, yep, we can do these things. 29, merger, the simplified way of saying, look, if there's any agreements, this transaction, this agreement has everything that we've talked about and agreed upon. Everything's on here. There is nothing else. Signatories and counterparts, the undersigned seller represents that all parties in title are a signatory on this agreement. This agreement may be signed at any number of counterparts. It's really saying the seller is telling us everything's on here. Those who are parties and have an interest, who need to sign, have signed, and are legally signed. Cancellation. This is one that I, again, want to make sure that everybody knows. This is an agreement that got entered into with two parties. It takes two parties to leave it. Therefore, canceled only by mutual consent and in writing. It can't be a simple, yeah, you're fired. Can't be that. There's got to be an agreement between us and the seller. From there, simple that they've received a copy of this. When you're working with the agreement, the company name is going to be in here. Sellers sign. It's dated. You will sign as the designated agent. It will already be there for you in most cases, and in the date that you sign and execute the document. So guys, get together with your manager or broker if you have additional questions on this. But I say go out and talk to people. Get a couple of these signed. See ya.